Yes, sir.
After this case number 20 CR 236, State of Ohio versus Ivan McClure. This hearing is being conducted by Zoom due to COVID-19 safety measures. See, Mr. You are Ivan McClure on the phone.
Yes.
On my screen is Ivan's phone, my phone.
Yes, sir.
All right. Also present is his attorney, Martin Trout, attorney, assistant prosecuting attorney, and same representative in the state. Also, Mr. Argina, who's pretrial services, and Mr. Green is also on session. Chief of probation department. McClure is charged with gross sexual imposition, fourth degree felony. Matter set for trial taken April 12th, 15th. Court was notified last week that there had been an agreement reached, and some matter was set today for a plea hearing. Now, before we continue, Mr. McClure, if you need to talk to your attorney at any time during this hearing, just let me know. You're not sitting with him in court, obviously, where you can talk to him at any time. So if you need to talk to him, I can push you and him into what's called a breakout room, or if we just do you on the screen, talking to each other, no one else will be able to hear you, you won't be recorded. Okay?
Yes.
All right. And Mr. Armitage, you and your client are both stipulating that this hearing be conducted by Zoom rather than in person.
We are, Your Honor.
And that's all right with you, Mr. McClure?
Yes, sir.
All right, thank you. All right. Now, Ms. McClure, I've been provided with a plea of guilty form. I'll hold this up to the camera, your screen, and it has your name on it and a case number, and it says plea of guilty. You see that form there?
Yes, sir. I see it.
All right. And on page 3, there are signature lines, and near the top of the page, there's a sentence that says, "I entered this plea voluntarily." And below it, the signature looks like Ivan McClure. Again, I'll hold that up to you as well, right?
Yeah, I signed that.
All right. And when did you sign this, Mr. McClure?
I think it was last week.
Okay. And where did you sign it, Mr. Armstrong's office?
Yeah.
All right.
Yes, sir.
Did he go over this agreement with you before he signed it? Explain to you?
Yes, he did.
Okay. Did you read through the entire agreement with him?
Yes.
And did you understand that this agreement to plead guilty, which means there's not going to be a trial on the 15th, and the next step in your case would be a sentencing hearing?
Yes, sir.
Right now, on page 1, well, let me back up. Have you had enough time to fully consider this matter before making this decision to plead guilty?
Yes, I am.
And are you entering into the agreement to plead guilty voluntarily?
Yeah.
Okay. Now, on page 1, it states that you're going to withdraw your not guilty plea, enter plea of guilty to the charge in count 1 of gross sexual imposition under section 2907.05A1, a 4th degree felony. It further states that you understand that the maximum penalty for that if you were sentenced to prison is 18 months, the minimum would be 6 months. If there's a prison term imposed, there's also a fine payable of $5,000. And there's a requirement that you be designated as a tier 1 sex offender, which means you'll be required to register as a sex offender with the Sheriff's Department for a period of 15 years, I believe it is, Mr. King.
I believe that's correct, Your Honor.
15 years with annual verification. You understand that?
Yes, sir.
Now, are you facing any felony charges in any other jurisdiction?
No.
Are you currently on probation, community control, parole, or post-release control from any jurisdiction?
Just probation here.
Just the pretrial supervision in this case?
That I'm on probation. I gotta see my probation officer Francis for busting a window in the jail and busting.
All right, that's for felonies is what I was asking about. You're not on probation for another felony?
No, sir.
Okay. Now, if you should be sentenced to prison for this offense, once you complete that prison term, it is mandatory under Ohio law for this type of offense that you put on what's called post-release control supervision for a period of 5 full years, which means you'll be supervised by a parole officer, a term set by the parole authority, because the court has no fault with that. Now, if the adult parole authority finds during that period of time that you have failed to comply, they could return you to prison even though you served the entire term set by the court for an additional period of up to 9 months for one violation, but there would be a cap of half of the prison term imposed, so the maximum could be 18 months, so that again could be maximum for all violations. But if you were to commit a new felony while you were under post-release control supervision, then an additional whatever sentence the judge in the new case would impose upon you, that judge could also sentence you in this case for committing that offense under post-release control supervision to an additional period of 1 year, whatever time would be left on that 5 years of post-release control, whichever is greater. If that occurred, that would have to be served consecutively with the sentence in the new case. Do you understand that?
Yes.
All right, now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called non-prison or community control sanction. What that means is that instead of going to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years on a term set by the court. And if during that period of time the probation department felt that you were not following those rules, they would file a notice of that in writing with the court, and you would get a copy. Then there would be a hearing in which you would be represented by an attorney. And if the outcome of that that hearing was that you failed to comply, then at that time the court would revoke the community control and then sentence you to prison for 18 months and fine you $5,000. You understand that?
Yes, sir, I understand that.
Right now, the charge in this case alleges that on or about July 19, 2020, in this county, that you had sexual contact with EA, and are the initials, not the spouse of said Ivan McClure, or you caused EA, not your spouse, to have sexual contact with you, or you caused EA and another to have sexual contact, and that you purposely compelled EA to commit by force or threat of force, violation section 29 and section 105A1 of the Ohio Vice Code. So that's the charge of gross sexual imposition, which we, again, explain carries possible prison term between 6 and 18 months, possible fine of $5,000, and the designation as a tier 1 sex offender. Now, Mr. McClure, do you understand what you've been accused of, what the state said you did, when, where, how,
Yes.
what you did?
I understand, sir.
And have you discussed the nature of the charge, the evidence of the case, possible legal issues of the case, possible defense you can try to raise a trial, and possible outcomes of a trial with your attorney?
Yeah, my attorney. On the trial yet?
And are you satisfied with his advice and confidence in this matter?
Yes.
Now, are you under the influence of any types of drugs or alcohol?
No, sir.
Are you taking any prescription drugs?
No, sir.
Now, have any threats been made against you to make you plead guilty in this case?
No, sir.
Now, on page 3 or 2, there is 3 lines that are printed in bold underline, just starting right about in the middle of the page, slightly below it. You see that? We're holding that up with my finger right next to it.
Yes, I see it.
All right. So I will read that. Those 3 lines. It says, defendant shall enter plead guilty to the indictment, state defense jointly recommend community control treatment. Defendant or the victim is in favor of the defendant obtaining treatment. Defendant shall be a tier 1 registered sex offender. Now, is that your understanding of the agreement? I didn't hear you, Mr. Clerk.
Yeah, that's my understanding, sir.
All right. Has anyone promised you anything other than that in case you plead guilty here?
No.
All right, now, under the law, Mr. McClure, the matter of sentence is reserved to the judge, not to the parties. And so even though you, the state, and even the victim apparently are recommending that you be given community control rather than being sent to prison, once I've heard all the information, if I think that's not the appropriate sentence, I could sentence you to prison for between 6 and 18 months and fine you $5,000.
Yes, sir.
In addition to the tier 1 registration, you understand that?
Yes, sir, I understand.
Okay. Now, do you hold any license or certificate from any state agency or board or any kind of a profession or occupation?
No, sir.
Okay. You have certain rights you must understand this before I can accept a guilty plea from you. First of all, you have a right to have I'm sorry, let me start over. You have the right to have an attorney to represent you in this matter, and I appointed Mr. Armstrong to represent you. Now, he wasn't appointed simply to work the case out, but to provide any defense that might be available to you under the law as you wish him to provide. So if you decide you do not want to plead guilty, he will still represent you and defend you, including having a trial if that's what you want. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that are from this county that are summoned for jury duty on your trial. Once they are selected, then again, it would be 12 people. They would hear the evidence and be instructed on the law. And then those 12 jurors would have to decide by a unanimous verdict, meaning all 12 have to agree on any verdict, whether or not the state proved your guilt or proved beyond reasonable doubt. Now, if you did not want to have a jury trial, if you did not want to plead guilty, then you can waive in writing, which means give up. Waive means give up in the legal sense. In writing, you're right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning that instead of the jury hearing the evidence, the judge would be the one who would hear the evidence, the judge would be the one who would apply the law, and the judge would decide whether or not the state proved your guilt or proved beyond reasonable doubt. Do you understand that?
Yeah, somewhat.
Okay.
I'd like to talk to my attorney about that.
All right. I'll put you in the breakout room. All right, we're back on the record. During the break, the defendant and his attorney discussed whatever it was Mr. McClurdy discussed in this case. So are we ready to continue, Mr. Armstrong?
Yes, sir.
All right. So I'll go back then to the question, Mr. McClure, that is, you understand that you have the right to either have a jury trial or a court trial in this matter, depending whichever one you want, would be up to you. And if you had a jury trial, the verdict would have to be unanimous, meaning all 12 have to agree on whether or not the state proved your guilt of the charge. Understand that?
I understand it.
All right. Now, under the Constitution, Mr. McClure, you have the right to confront the witnesses against you And cross-examine for your attorney. What that means is witnesses have to come in court and testify in front of you and your attorney, and anyone else might be present. After the prosecutor then asking questions, your attorney has the right to ask questions. That's called cross-examination, and the purpose of that is to bring out evidence to help your side of the case. Do you understand that?
Yes.
And under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain can come in voluntarily to testify, to request court issues a court order that's called subpoena, then don't force those witnesses to come to court and be able to testify for one of the two, even though they don't want to be here. Which is the same way the state witnesses are forced to come to court. Do you understand that?
Yes. Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including the trial. So no one can ever make you testify. The prosecutor can't, the judge can't, you make the decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to talk about it except in one situation. If there's a jury trial and you don't testify, then the judge instructs the jury that because that is your right, they cannot consider that for any purpose. You understand that?
Yes, sir.
Right now, under the Constitution, Lord, you're presumed innocent until proven guilty by the state of Ohio in every essential element of the offense charge. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused of this offense. In fact, under the law, you're not required to present any evidence at all. That's right. You can, but you're not required to. Whether you present any evidence or not, the burden of proof will remain upon the state of Ohio. Prove your guilt on every essential element of the offense charge or prove beyond reasonable doubt. That's the highest burden of proof that's known in the law. You understand that?
Yes, sir, I do.
I'm thinking I might have messed up one thing, so I'm going to go back and cover that again. That is that under the Constitution, you have the right to confront the witnesses against you and have your attorney cross-examine. So any witnesses that testify would have to be here in open court. You would be able to ask that question once the prosecutor's done. That's called cross-examination. And the purpose of that would be to bring out evidence to help your side of the case. You understand that?
Yes, sir.
You understand that you can use the power of the court to make witnesses come to court for you, just like the state.
Yes, sir.
Okay. Now, you originally entered a plea of not guilty. A guilty plea denied the allegations in the indictment, denied you committed any crime. That exercise or invoke all the rights that I just described. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty. The guilty plea admits the allegations in the indictment, admits that they're a crime, and that you're the one who committed that crime. That plea waives or gives up all of the rights that I just explained for you here this afternoon, except the right to have an attorney. You have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives gives up the right to a jury or a court trial. Waives gives up the right to cross-examine witnesses tendered for your attorney to try to bring out evidence to help your side of the case. A waive gives up the right to use the power of the court to compel or force witnesses being forced to testify for you, just like the state. Waive gives up your privilege of self-incrimination because you say you're guilty, that's what's used to find you guilty. It also waive gives up your presumption of innocence because if you say you're guilty, then the state's not required to prove that you're guilty. It also subjects you to being sentenced immediately by the court. The court chose to do that. And it waives gives up any right to file an appeal which you think you may have had up to this point in the case. Now, if I should sentence you to the maximum sentence, then you could file an appeal, and that would be other limit rights you could, but it would have to be filed for 30 days from the entry of sentencing to be filed with the court. Do you understand all that?
Yes, I understand. Can I go talk to my attorney again?
Sure.
Thank you.
All right, we're back on record. Now, are we ready to go ahead and go forward, Mr. Clerk?
Yes, sir.
Okay. Now, do you have any questions about the charge and possible penalties, Mr. Clerk?
No, sir.
You understand them?
Yes, I understand all.
Do you have any questions about the plea agreement?
No,
Do
sir.
you understand it?
Yes, I understand them.
And again, you understand the recommendation on sentencing is not binding on the judge.
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what the consequences of that plea could be if you enter here today?
No, sir.
Do you understand?
I understand.
Now, is there anything else you would like to speak to your attorney about before we go any further?
No, sir.
Have any questions about any of the things that I've explained to you here this afternoon?
No, sir.
Then, Mr. McClure, is it your decision to change your plea from not guilty to guilty in accordance with the terms of this plea agreement?
Yes, sir.
And you've had enough time to fully consider this matter and talk to your attorney twice a day, so you're certain this is what you want to do?
Yes.
Okay. And then as to the charge, which alleges that on or about July 19, 2020, County, Ohio, you did have sexual contact with EA, not the spouse of the said Ivan McClure, cause EA, not the spouse of the said Ivan McClure, to have sexual contact with the said Ivan McClure, cause EA and another to have sexual contact. The said Ivan McClure had virtually compelled EA to submit a force of threat force in violation of section 2907.05A1, the higher revised code, charged of gross sexual imposition, a fourth degree felony, section 2907.05A1, the higher revised code, carrying a possible prison term between 6 and 18 months, a possible fine of up to $5,000, and mandatory duty to register as a tier 1 sex offender. How do you plead?
Guilty.
Right? Court finds that on this day in open court, the defendant was advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of same pursuant from Rule 11. Plea is accepted as ordered in trial. The defendant is found guilty of the charge. The court will order a pre-sentence investigation, including assessment for possible substance use disorder and or mental health issues. Bond will be continued. Sentencing hearing will be set for May the 5th, 2021, 9 a.m. That will be in person, not by Zoom, Mr. Clerk. I'm conducting all sentencing by in person now instead of by Zoom.
Yes, sir.
Your Honor, if I may,
Yes.
I'm not available on May, I'm out that week.
Okay. You're out for the whole week?
Yes, sir.
All right, then we'll set that for May 20 at 1 p.m. All right, you'll need to contact probation department. Mr. Argini, you want him to call you right after this is over? Or I guess you're going to report to your other probation officer, yes, aren't you? Mr. McClure.
I'm going there tomorrow. I got an appointment for tomorrow with him.
Oh, okay. So that'll, okay, well, you need to talk
It's
about getting your that's for the pre-sentence report.
He can do it while he's there, he can get it set up, so
Okay.
that's fine
So
tomorrow.
you're going to report for your other case, plus you're going to be talking with them about getting your pre-sentence report prepared for the hearing. That'll be the report that the officer will prepare that gives me on various information about the case, about you, so that it can be used for sentencing. So, and also, I'd like you would tell Mr. Fulton and Mr. Arshima to request a copy of the bill of particulars case. Those are filed here, and I need to have that in the record, look at it when I make my decision as to the sentence.
Just one.
Okay, anything, further, council?
No, Your Honor. No, Your Honor.
Okay, Mr. McClure, you don't have to be here on the 15th of April, you have to be back here on May the 20th at 1 p.m., and that will be in person here.